Good day, my name is Abdullah. I'm the Deputy Executive Director of the Muslim Legal Fund of America. Today I'm sitting with two principal attorneys from the Constitutional Law Center for Muslims in America, with Charles Swift, who is the Director of the Law Center, as well as Christina Jump, who is the Civil Litigation Head of the department within CLCMA. Today we're going to be talking about the news reports that are coming out that the Trump administration has created a special task force to denaturalize American citizens. So, Christina, can they actually take their citizenship?
They can, but only under very limited circumstances, and there is a high burden, fortunately. So there are safeguards in place, even if they do go ahead with these plans and aggressively make these attempts. What the administration needs to do, first of all, is file a federal court lawsuit. So this gets us out of an administrative hearing in the standard immigration context. Because remember, the people that we're talking about are current U.S. citizens. So they're entitled to all of the same rights of all U.S. citizens. And this needs to be a lawsuit that they prove and win in front of federal court judges. In order to do that, the government needs to file a lawsuit and give the citizens they are challenging an opportunity to respond. And the government has the burden, which is a very high burden, higher than most civil cases, of showing by clear and convincing evidence that the citizenship that was originally obtained was done so unlawfully, that there was either a misrepresentation, which is material, or in some other way that they illegally procured, meaning got the citizenship against the standards that are set forth under the law. And we get a chance to defend against that. The individuals have a chance to defend against that if they take the right steps and answer in time.
So Charlie, if the standards are so high, why is the government doing this?
Well, I think that this is my opinion. I think that they're counting on the fact that it's in civil litigation instead of criminal. In criminal litigation, everyone's afforded an attorney. They have the opportunity, whether they can pay for one or not. That's not true in civil litigation. So any member of the newly acquired citizenship community, an immigrant community that's naturalized, when they face these proceedings, won't be necessarily provided an attorney. In fact, they won't be provided an attorney. The government is hoping, in my view, that a vast majority of people will do what people often do when they receive a civil lawsuit or they come into a civil proceeding. They ignore it. And if they ignore it, then the government wins by default because you have to defend the suit. Or they try and go in and defend it themselves. After all, most of them got their citizenship without an attorney. Why would they need one now? But they're in a far different place. Federal court has very stringent rules regarding civil procedure and how one proceeds. It is a difficult place to navigate unless you have someone who is skilled in civil litigation in the federal courts. If that happens, then the administration has a huge uphill burden. But they're counting on the fact that most immigrants won't have an attorney.
So you don't get an attorney if it's in civil court.
That's right. When you do not get, you can hire one, but you're not automatically appointed one.
So the government does not give you an attorney if you can't afford one.
That's correct. And that's an important point. We at CLCMA take on these cases at no cost, pro bono, for our clients. And so we've litigated these cases and are litigating these cases.
I just want to make one point clear. The reason why you're able to do pro bono work is because there's a grant funded by the Muslim League of America.
That's right. Without that grant, then there is no representation. And it is essential to have representation in this case. My view is that the Miller Plan has a great chance of succeeding if the targets of this aren't represented, that they are literally left undefended. And if they're not defended, then the Miller Plan will have a good chance of succeeding because there's no defense.
Who's actually bringing this up?
Well, we've received news reports, and it's been widely reported in the press, that Stephen Miller, one of the principal assistants to the president and one of the architects of the original Muslim ban, reportedly the principal architect of that ban, has, in the wake of Hawaii v. Trump, started a new initiative, and that is to utilize the government's powers under 8 U.S.C. 1451, which is the Denaturalization statute, to try and strip persons who had previously received their citizenship of their citizenship.
Can that be actually done?
It can, under very limited circumstances.
How concerned should Muslims be?
They should be very concerned. The administration has proven time and time again that it isn't all talk when it comes to these actions, that they actually try and do it, and they try and do it in a way that is extraordinarily hostile to recent immigrants to the United States. And Muslims make up a large percentage or a large part of that population, and they're an area that have been particularly targeted by this administration. So they should be concerned with the announcement of this task force.
So Christina, this is a tricky question. Will everyone be targeted?
No, we don't believe that every naturalized citizen will necessarily be subject to a denaturalization lawsuit. It is, again, a high burden, and I think that the government is likely to pick and choose its cases and have some identified targets that they will go after. That will be a small percentage of those overall who have been naturalized.
This is a very serious issue, and how will someone know that they're being targeted?
There are two main ways that individuals should be put on notice and things that they should look for to identify that they may be targets of a denaturalization investigation and subsequent lawsuit. The first thing is if anyone shows up at their door asking to reopen interviews. And while the initial process for obtaining citizenship obviously goes through the immigration process, and is through ICE or immigration officials and the meetings that people show up for and sit down and have recorded. There may be an FBI agent, there may be an ICE officer, there may be other government agents who show up to this person's door or start talking to their relatives and asking questions that sound like they're the same issues already covered, that go back in time and want to reopen some of the issues addressed already in the citizenship proceeding as to where they came from, why they're here, how they obtained their citizenship, if it was based on a marriage, what was the status of the marriage, those sorts of things. So that's one way. If you notice that government agents or officers are showing up and trying to ask questions that were already covered during the original proceedings. The second way that individuals will know is a lot clearer. They will get a notice in the mail that flat out tells them that the government is planning a denaturalization action against them. Now, this notice is just a piece of paper. It's mail. It's not being served yet. The government is required to do this 30 days before they file the lawsuit in federal court. But it's only 30 days between receiving this notice or the notice being sent out and the time that the lawsuit is filed. There's a possibility that it could go to the wrong address, it could go to an old address, and it may get lost in the mail. It may not look like anything official or that requires much action. But then the most important part after that is that the individuals will be served with the lawsuit. So there will be a federal process server who comes to them and serves them with this lawsuit that has, by this point, been filed in federal court, where the government is trying to prove that these citizens are no longer entitled to their citizenship because, under the government's argument, they never really were. And at that point, the individuals only have 60 days to file an answer in federal court with all of their defenses.
Wow, that is a very serious issue and matter, and this cannot be taken lightly. So what should someone do if they do receive this notice?
Well, if they receive the notice or the FBI or someone else attempts to interview them, what they need to know is they need an attorney. They need an attorney right now, not later, not in the event that hope is no longer a course of action. They must get an attorney, in my view. Being unrepresented, even in the initial stages, it's very hard to undo something that was done early. And when you don't understand federal litigation in the process, you can make mistakes. And I would say that if I were a naturalized U.S. citizen and received one of these notices, I'd hire an attorney, and I am one, because I need independent legal advice. Whoever receives it needs to get an attorney, and they need to get an attorney who knows what they're doing. Now, that may pose a problem, because there are a lot of people can't afford an attorney. The question is, how much could something like this cost? Well, I would say to hire somebody who's skilled in federal civil litigation. The average hourly rate is somewhere between $400 and $500 an hour, and the length of the proceedings, et cetera, on this sort of thing can be hundreds of hours. So it could cost anywhere from $50,000 to several $100,000 during the course of such a proceeding. So it does pose a significant financial burden. Now, if you can't afford that, that's why we're here. We would urge you to immediately contact the Constitutional Law Center for Muslims in America to get help. We're going to accept as many cases as we possibly can. That's our goal. We'd like to be able to accept them all. Whether we're sufficiently funded is going to decide that. And I know MLFA is committed to raising the resources to ensure that we have the staff necessary. We don't know how big the problem is, but we know that Stephen Miller is talking about hiring 80 to 100 attorneys. Right now, we have 3 to 4 to dedicate to that kind of work, along
within
with
the civil department.
Within the civil department, to dedicate, and that includes myself and others who are, we're cross-hatted. This isn't our only case, but we're dedicated to taking as many of these cases as we can, because we understand that this is the next threat, and and it's something I think we do well, and we want to do it well. So we want to take on the case. We certainly want to help you at the onset to make sure that whoever the viewer here or anyone that they know who's facing this makes the right moves initially. Because if you don't make the right moves, much like chess, the opening dictates the game. If the game is opened incorrectly, then the game may be lost at the very beginning.
So within the 60 days of notice, one of the first things that an individual should do is get in touch with an attorney.
Absolutely. And I would certainly recommend that any individual who receives the first notice, even before they're served with a lawsuit, putting them on notice that they may be subject to a denaturalization challenge, should certainly consult a qualified attorney at that point. The tricky part here, a lot of times, is well-intended as any attorneys may be. These suits require the combination of knowledge in several areas. They require detailed knowledge of how to litigate a case in federal court. So it shouldn't be somebody's first time in federal court. It shouldn't be somebody's first time taking something all the way through to a trial in federal court that they take on a case like this. An individual who receives such a notice or eventually gets served will want somebody who already has experience in federal court and with federal court civil procedure. They also want someone who is aware of ramifications of criminal law and someone with at least some working knowledge of the immigration statutes that are at issue here. So it is a civil case, but it certainly brings in, depending on the situation, both criminal and immigration aspects. And you need someone who has knowledge, or at least the references to be able to get to that. Once someone has been served, they absolutely need to contact an attorney, as Charlie indicated, as soon as possible. If we are contacted on a case like this and an individual has already been served, the very first thing we want to do is become as informed as we can before the first document we file in court. And if we're not contacted until a day or two before the deadline, it's very hard for us to do that. So the more lead time that we have, the better we can do. And we will do things like pull as much of the information as we can about what the stated reason is. Now, the good thing about a civil lawsuit, as opposed to an immigration proceeding, is that the government has to state in its opening filing what exactly is the basis for the challenge to the naturalization, and therefore why do they want to denaturalize.
So they have to mention their cause in the documents.
Absolutely. They have to state it clearly. They have to state what category it fits, and they have to explain the facts, more importantly, that they believe support that. So if we have that, we want an opportunity to investigate those facts before that 60 days runs, before the time to answer, so that we can be in the best position possible for our clients to be able to answer, to be able to assert the right defenses, and to be able to point out where the gaps are in the government's argument.
Charlie, why is it important for CLCMA or organizations like CLCMA to take on these sort of cases and defend individuals who are being targeted?
Well, there's two reasons. First reason is without representation, injustice can and will occur. And an injustice for one person anywhere is an injustice everywhere. There's a second reason, though, a broader reason for the community. If it isn't fought back, the administration, the Justice Department operates on a don't lose basis. So if they go into court and they're successful, then they keep pushing. But if they lose, and they lose in a highly coveraged case, like a case we just did, the United States versus Solomon, which was the shooter's wife in Orlando, when they lose that way, it changes behavior. It changes the task forces that they're going to take on and the cases they're going to take on. And they are less likely to keep trying to take on individuals for which there is really no reason, or just, maybe we could do this in the process. And so if you push back, you can stop them. But if you don't push back, there's no pushback, then they will go as far as they can until there is pushback. Because that's how this administration operates. Look at the Muslim ban. They lost once. Did they stop? Nope. They wrote another one. They lost again. Did they stop? Nope. They wrote a third one. Now they ultimately prevailed on that third one, so they've gotten forward on it. It changed a lot of things in it to prevail. But what you saw is they never stopped. Unless you push back. And they would have gone with the Muslim ban. If no one had pushed back, that the first policy would be the policy. Well, in these cases, the law is set. This isn't a new law. It's the new application.
So there has been denaturalization processes before?
Oh, absolutely. Denaturalization, this statute has existed since I think at least 1900. Predecessor goes back. There were significant denaturalization cases during the Red Scare. There have been denaturalization processes in conjunction with a quote-unquote attack on the mob. There have been denaturalization processes through modern U.S. legal history, and there's quite a good deal of case law on it. It's not new. What's new is this idea that I'm going to go through, create a special target, and a special task force, and target individuals. And if we look at who's creating that task force, Stephen Miller, and his past history, then we know what he's targeting, because
we know what he's targeted before.
So I want to thank Christina and Charlie for sitting down with me today to talk about this imminent danger that's happening to the Muslim community as well as the larger immigrant community here in America that have been naturalized through the various different steps that they've taken. And today, as you can see in the Trump era, we have various different issues, and these threats that are being mentioned, whether it be by the president or the administration, cannot be taken lightly, because we had the first Muslim ban, the second, and the third. This new task force has said they are going to do it. You know what? It's probably going to happen. And when it does happen, you do need to reach out to an attorney so that you can get the best legal representation. Today, we are being able to fund CLCMA by the generous donation of individuals like you, as many others all across the country, so that justice happens, so that we can protect the rights of Muslims and Americans in this country that are constitutionally given to them. If you need an attorney or if you've been served with such a notice, please contact CLCMA.org. And if you want to support this effort financially, please visit our website, www.mlfa.org. Thank you very much. Good day.